Well, we have here today Professor William Gould, who's a professor emeritus in law down the road at arch rival Stanford. He's one of the country's leading experts on labor and discrimination law and was the chairman of the National Labor Relations Board under President Bill Clinton. He has also served as an arbitrator for salary disputes in Major League Baseball. So please welcome Professor William Gould.
Thanks very much, Peter. I thought David would be here and that he would lay out a lot of the background, and I'm afraid that I hope my remarks don't fall with too much of a thud here, because my remarks are going to be focused mainly on the peculiar legal framework that affects the employees, the players, and the owners, the employers. Sports is very different from labor management relations, particularly as it has evolved during these past 3.5 decades. Peter referred to the situation as it was in 1955, 35% of the workers represented by unions. Now, today in the private sector, 7%. That really gathered steam and began to move in the late 60s and the early 70s. That's just the time that the unions come in all of the major sports. Baseball had a union since 1954, but it really wasn't a union. It became a union with Marvin Miller in the late 60s, and that's just the time that the football players are coming on, the NFL Players Association is coming on the scene, and the Basketball Players Association also as the result of the so-called Oscar Robertson antitrust settlement. Now, another basic difference between sports and labor management relations that's going to affect most of my remarks here today it relates to the fact that sports is affected both by labor law but also by antitrust law. And that's going to sound counterintuitive to many of you who have been involved in labor management relations. 2 points I want to make right at the outset. One is, antitrust law is robust. But if you violate the antitrust laws, you really have some consequences to face. Treble damages, as well as injunctions, even in some circumstances, criminal prosecution as well. 3 principal remedies for violations of the antitrust law. Now, the unions fought antitrust law historically. And why did they fight antitrust law? They fought because antitrust law is on a collision course with labor law, which, by the way, today, particularly compared to antitrust law, irony upon irony, is infinite and weak. And antitrust law, remember I've just said, is robust and significant. Now, and the football players found out how weak labor law was when they struck in 1987, and when their ranks were decimated by replacements, and they went back to the drawing board and they said, hey, we've got to find another way to deal with this problem. Now, the reason that the unions have fought antitrust law is that antitrust law historically, and for the most part, is on a collision course with labor law. And that is to say, antitrust law promotes competition. It's supposed to promote competition, and labor law is to take competition out insofar as labor cost considerations are involved. So, yes, we want you to be competitive and efficient, but we don't want you to have workers competing with one another and driving them down to the lowest common denominator. Well, long story short, along comes, in 1932, the NorrisLaguardia Act, which turns out to be at the heart of one of the big legal issues involved in this lockout today, which basically, by virtue of the Supreme Court's interpretation of it, takes antitrust out of the picture where unions act on their own, where unions engage in self-help, strikes, picketing, boycotts. They've been circumscribed by the Taft-Hartley amendments and other provisions of labor law. But the Supreme Court interpretation of NorrisLaguardia, 1932, which said that courts, federal courts, have no jurisdiction to issue injunctions, and the Supreme Court said impliedly to fashion damages in labor disputes, antitrust out of the picture. But as unions and employers came together, we find that antitrust law was revived by the so-called non-statutory, I hate to use these words, but let's just say it and run with it, non-statutory labor exemption to antitrust law. That is to say, where unions agreed with employers upon conditions of employment as a general proposition, which would be a violation of antitrust law in vacuo if they did it in a collective bargaining agreement. Okay, I'm simplifying here. Okay, now, the situation in sports is kind of role reversal, because the employees in sports, they want the free market to some extent. They want the free market because they're entertainers, other entertainers, they want the free market within limits because they will get, Joe Montana wants the free market. A lot of people want it. Joe Montana. Actually, for a variety of reasons, nobody else could get him other than the 49ers. But a lot of players benefit in entertainment and in sports in particular by virtue of the free market. Well, the employers want to put a lid on that free market. You see, the employers want to put a lid on that free market, and they're able to do that in some measure, which we'll learn more about in just a second. Now, antitrust law is applicable, has a real kick in professional sports because, and the Supreme Court only articulated this last year in the so-called American Needle case, because each team is viewed as a separate entity competing with the other for labor. So that when these teams get together and they say, the quarterback for the Cleveland Browns can't move to another team, well, they are colluding in restraint of trade, in restraint of labor. And they are generally violating the antitrust law. 1922, the Supreme Court had said in a case where most people thought that Justice Holmes, lawyers and law professors and judges have bad days just like ball players, and Justice Holmes got up maybe on the wrong side of the bed one day and wrote an opinion called the federal baseball case, where he said baseball isn't covered by antitrust law. So that even if, and that remained the law, it still remains the law, with certain limitations today because of the Kirk Flood Act of 1998, which carved out exceptions to what Justice Holmes did in 1922. But in 1956, along came a football player named Radovich, who was not able to go to the team he wanted. In fact, the NFL was boycotting him because he went to the team that they didn't, just like the baseball owners were boycotting the guys who went to the Mexican League in the 1940s because they wanted to teach him a lesson. And they tried to keep him out. He sued under antitrust. He said, "You're boycotting my labor." And the Supreme Court said, yes, this is proven a violation of the antitrust law. So antitrust law is in the picture in sports, but the unions have wanted to do certain things collectively. And so in football, for instance, they've negotiated pensions, they've negotiated minimum salaries, all the major sports, minimum salaries, pensions, health care, safety provisions in the collective bargaining agreement, and within limits established in the collective bargaining agreement, people can go from one team to another. Now, the players first challenged the NFL under the antitrust law when there was a commissioner who was regarded as very successful in the NFL named Pete Roselle, who established the Roselle Rule. And the Roselle Rule is, hey, if you want to become a free agent, fine. You can go some other place to some other club, but the commissioner will decide what compensation your team has to pay to the team that you're leading. So guess what? Nobody was able to exercise whatever free agent rights they had. And the Court of Appeals in St. Louis held that notwithstanding the negotiation of a collective bargaining agreement, because the Roselle Rule was not bargained with the NFL Players Association, this restraint upon labor gave rise to an antitrust violation. Just as if General Motors and Ford got together and they said, hey, you know, this guy who's a welder for us, he's employed with you at Ford. So he can't work for, we agree that he can't work for General Motors. That also would be something in restraint of trade in violation. Of course, that doesn't happen because nobody is paying to come and see that welder with lots of crowds and lots of money and television involved. Now,